My name is Pete Wright, and my wife and I have the Wrightslaw.com special ed law and advocacy website. This video is about parents being able to obtain copies of their child's test protocols. Test protocols are considered to be education records pursuant to FERPA, the Family Educational Rights and Privacy Act. FERPA is in Title 20 of the United States Code, Section 1232. It's in the Law Book, Chapter 9. FERPA is not specific to the Individuals with Disabilities Education Act or to a Section 504 child, but instead applies to all children. And the key has to do with the two words education record. So we'll look at the statute right now. What you're looking at is the first cover page of our special ed law book, and in the table of contents you'll see different chapter headings. This is the special ed statute, these are the special ed regs, but the critical one for our purpose is right here, Family Educational Rights and Privacy Act. And I'll show you a good way to use this if we just simply go up into the search engine and I'll put a beginning quote, education records, end quote. That way it'll search for the phrase educational records, and it found it on 21 pages. And I'm going to go all the way down to chapter 9 on the sidebar here on the right hand side, because I know that chapter 9 is the FERPA statute where we have it in the law book. And so there's the chapter 9, the FERPA statute, and this is the definition right here, and again here, all in the same immediate area. This is the key language. I'll close the sidebar now. The key language is right here, and I'll zoom in. For purposes of this section, education records means those records, files, documents, and other materials which contain information directly related to a student are maintained by the agency or institution, and then explains what it does not include. And then it goes on further and talks about directory information and the right to obtain the release of the records to the parents. So let me go back up now to the beginning part, that parents have the right to inspect and review all educational records relating to their child. The right includes to have copies of records, receive explanations, etc., and it must be done within 45 days. So when you're requesting documents from the school, use the phrase education records rather than the file or whatever else. That way FERPA kicks in. There have been several legal decisions relating to the parents' right of access. In 1987, there was a state court ruling out of Illinois. In 2005, there was a ruling out of California from a U.S. District Court. The state court ruling John K. versus the Board of Ed, and this is the legal citation for it, 152, Illinois Appellate 3rd, page 543. The court held that a school district had to release to the parents the verbatim transcript of their child's Rorschach responses. The school did not want to do that. The court said they had to because they were education records. The really critical case, though, that I like a lot and I think you will enjoy is the one out of California in 2005. It's the Newport Mesa Unified School District versus the California Department of Education. In this instance, Newport Mesa sued the California Department of Education because the California Department of Ed told them they had to release the test protocols. So it's a federal court ruling which interpreted state law vis-a-vis federal copyright law. State law said one thing, but the school district argued that the federal copyright law prohibited the school from releasing the records to the parents because it would violate the federal law. The actual decision as it was published and printed by the district court is on our website. That's the URL for it. However, it's much faster to find it if you go to our website and simply type in Newport-Mesa, and you'll find it much faster than trying to come back and find this URL. In that case, the district court held that a California statute requiring that copies of test protocols be provided to parents of special ed students falls within what is considered to be the acceptable fair use provision under the federal copyright law. And what the court did, which is interesting, they didn't limit it to being just a case between a school district and the California Department of Ed. The court had the publishers of the Wechsler IQ test and the Woodcock-Johnson test intervene in the case, and actually had them become involved in interveners in the case, because the court said if anyone has the right to complain about a copyright violation, it wouldn't be so much a school or a school psychologist, it would be the actual test publishers. So they became, in essence, parties in the case, and then in the end, the court held that parents were entitled to the child's test protocols. Okay, let's assume you want to find cases, whether it's a case of this nature or some other kind of case. I suggest what you do is you go into Google Scholar. Many people don't know about it. Let me see if I can get that for you. Google, there's a tab that says More. Click on the More. Scroll down to Even More. And now you'll see many more options. Scroll down to Google Scholar. This is Google Scholar. Click on that. Then when you're in Google Scholar, click on Legal Documents. And then what I was using was I want to find out about parents' right of access to education records. And I'm thinking about special ed and also Family Educational Rights and Privacy Act. So I'm going to put all those in there because if there's a legal decision, it would include those words. So I'm simply going to type in parents, and you see I've already done this before, and you see how it popped up, to, and then quote, education records. That way it'll, rather than just finding the word education and finding the word records, it'll do it as a joined phrase, and then quote, special education, and, beginning quotes, I want the full phrase, family, educational, rights, and privacy act, end quote, and go find. And right away, bang, it found 93 results. And here's some cases: Gonzaga, Honig versus Doe, and you'll see just a number of different cases where those words were in the decision. And I'm going to go on for a few more. Let me back up, hit the back button. One thing I should do here, I guess I cannot do it at this point. It did give me the option before to limit it just to cases as opposed to articles. Let me click on 2. So here's some articles, and I did not want articles, and I should have narrowed that down. But here's article, and then here's the case in question that we just talked about. And so if you click on that, that's how you can find cases. Let's go back. Now to find more on this topic, or for example other topics, go to our own website, the Wrightslaw.com website, and I'm going to search education records, then I'll search FERPA, then I'll search protocols, just so you can see what will pop up. So let me go to Wrightslaw Special Ed, and this is the Google search, and I'll put quotes again, education records, and tell it to search. This is Wrightslaw.com. And so you'll see there's a whole lot right here, and I'll hold the command button down on my keyboard and then click, or that's for Apple. For Windows, Control, and then click to open it in a new tab. So you just saw at the top of the screen, open it in a new tab, and then here's a newsletter, analysis of regulations, organizing the file, more about education records. Now I go back up and I'll search FERPA. And so you see here is a whole page. I hold the command button down and then click, so open it in a separate tab. whole page about FERPA, and then something in our blog, and then another thing about copying protocols. I'll click on that, and then more. And now let me go up and type in the word protocols. Protocol. And so here's more. It's probably, I think that's one we've already seen before. And I think we've seen this before. I don't remember now, but they all look alike after a while. But you'll see that there's quite a bit. And so now I'm going to go up to the tabs. And so privacy, confidential education records, and an overview about FERPA, and then links to the FERPA regulations, more about confidentiality, the California decision that you just learned about, National Association of School Psychologists. They have written a lot about this. Let me close that one. Go to the next one. And again, FERPA, and then we'll look at the next one. And this has more. And a parent writes in a letter. So this will give you an idea as to some of the stuff that's on the Wrightslaw website on this topic. National Association of School Psychologists, I mentioned moments ago, has a fair amount. So let's go back over there, and I have that tab already open right here, nasponline.org. And if I just go into their search engine box, which is right here, far right, type in protocol, and you'll see a number of articles they have with regard to this topic. And the National Association of School Psychologists talks about how parents are entitled to copies of the test protocols. So if you're dealing with a school psychologist, the NASP website has greater persuasive value than does Wrightslaw.com. A school psychologist who is trying to keep you from having access may not place a lot of weight on what we say, but they'll place more weight on what the National Association of School Psychologists has to say on that topic. So what do you really need? In Chapter 9 of our FIDA book, and also in an earlier YouTube video, we talked about the importance of getting a complete copy of a child's file. Part of that does mean the test protocols. Do we mean getting all the answer sheets that the child has written on? Well, technically you're entitled to that, but is that really of real value to you? It might be, but then again, it depends. It might not be. But the real thing that I want you to be sure you get are scores of all the different tests, the Wechsler IQ test, the Woodcock Reading Mastery test, the Gray Oral Reading test, all of the standard scores, percentile ranks, all of that test data. You want what's also known as a test summary data. I want you to get all of that because in Chapter 10 and Chapter 11 of our From Emotions to Advocacy book, you learn how to chart out your child's test scores to see if your child is, in fact, showing progress, is improving in the special ed program, or flatlining, or worse, regressing. So just very quickly, I will take you to the FIDA book. We call that the FIDA book. And I'm going to jump down to Chapter 10 and Chapter 11. This is Chapter 10. And our quote is, if something exists, it exists in some amount. If it exists in some amount, it is capable of being measured. So yes, you can measure improvement and change over time. We're talking about measuring growth, measuring various things. What do the tests measure? Reading tests, comprehensive evaluations, using the statistics to determine what kind of growth is being made. And then let me scroll on real quickly here to the next chapter. Chapter 11, quoting Jerome Sattler, the Dean of School Psychologists. And in this chapter, we go into more depth with understanding the test data, what's known as a frequency distribution chart, also known as a bell curve, and a little sheet about the quick rules. And then an actual conversion table. So you can, if your child has a standard score of 115, that correlates with a 13 on a subtest score, which puts the child at the 84th percentile rank. And this is a typical Wechsler profile of a child, not a typical one, but a profile of a child. in a case that I was involved in. But you use this data then for determining, a number of the different tests are discussed here further on in this chapter, but you use this data then to help you figure out about writing smart IEPs. You have to have data. In other words, you want to measure change over time. So let's assume that you are denied access. Then if that happens, go back and look at some of the resources in this video. Print out the Newport Mesa case and a couple of the National Association of School Psychologists articles, and then write a nice letter to the stranger. That's chapter 24 in our From Emotions Advocacy book, explaining your confusion about how you're being denied access and how these articles that you have seem to say something else, and you're really confused and you'd like their help in reconciling it, because if your understanding is correct, they're telling you that you do not have the right of access, and you're afraid you must be mistaken, and so forth. And I think you'll find that they may well may change their position on it if you present the letter in a way that there's not a pointing, blaming, or finger-pointing letter. We talk about that in chapter 24. So chapters 10, 11, 12, and 24. If you want to be notified of any future videos, please click on the YouTube Wrightslaw subscribe button just below this video. We have a free online newsletter that comes out once a week, and if you would like to subscribe to that, please go to our website. And thank you, and I hope that you have enjoyed this, and please send me any suggestions. This is a new venture for us, and we're kind of feeling our way.